With your Lordship's permission.
Knowing it full well.
With your Lordship's permission.
Knowing it full well that oral mentioning is not allowed.
But there is no oral mentioning allowed, particularly seniors. No question of.
But there is an extraordinary matter. Not that the case of women reservation where the order is still reserved. The order has
order has been released.
Not yet been uploaded. We have filed an IA. So only simple prayer that please go through the IA because of subsequent developments. A very long press interview by the lady advocates maligning the image of all the state bar councils, though
don't
respecting the sentiment.
Don't bother about what they say.
Now,
there might be some, even within the women law, there can be some people who might not be interested in this progressive approach.
No, what I say.
Don't be trapped by their.
No, what I say. Lord, respecting, Lord, the sentiment of this honorable court, supporting, Lord, the reservation, and if a wrong message has been given, Lord, this will be a history in the legal fraternity.
Mr. Message will go either from the bench or from your side. They are the beneficiaries. There is no question of any message from
that is the prayer, that a message from this honorable court, we accepted it gladly. All the state bar councils, bar council of India.
That's why in the order itself we said that we really acknowledge the pragmatic and very futuristic and very progressive approach of the Bar Council of India. That is one of the paragraph.
Lord, that's all we want.
That's absolutely.
Much obliged.
Without your support, it would not have been possible.
With your Lordship.
Instead of going for any amendment in the statute or anything, it's only because of your.
That's what, Lord, we wanted to convey, and we want.
Absolutely. That
much obliged.
Clearly mentioned.
Much obliged.
Written on the wall.
With your Lordship permission, I'm praying for listing of the BCCI matter. In this, we had filed an application by DDCA for holding the post of election for the post of secretary. The current secretary has crossed 9 over his tenure, and he's continuing.
And you think that the matter is so urgent that we should mention it today?
It was listed.
Please leave it. Don't entertain any.
Milords, I'm really
secretary so and so.
Milords, I'm really sorry for the inconvenience. I would not have mentioned had I had any other recourse. This is regarding the Samaj Parivartan matter. I mentioned it on the 25th of November and it was directed to be listed.
Is it a pending matter?
Yes, Milords.
Please give your
Milords,
three-judge bench matter. That requires composition of three-judge bench.
Yes,
it was not going to happen. There's only 1 week is left. In January opening, we will do it.
Grateful.
These are old appeals, any date 26, any date in the January or February, old appeals, 2014 appeals is earlier.
This is 2014 appeal.
14
appeal. Must be on the board.
No, subsequent, appeals are showing it's my appeal is.
Register to examine and explain the possibility of listing as per the.
Item 2 also, Lordship, same thing. 14 appeal.
All of. Item 3.
My Lord, this is an application for the early hearing. My Lord, is the case of the Provident Fund and the original issue is relating to the year 1999, my Lord. And my Lord, 2016 is the SLP, my Lord. It's in the leave granted case. I pray for the early hearing.
Application by whom?
Application by respondent number 2, my Lord, Regional Provident Fund Commissioner.
You don't pay to anyone. You are Provident Fund Commissioner.
I'm for the EPFO, my Lord.
Had you been working efficiently, then there would not be any problem.
No, my Lord, all the...
For collecting money, you don't pay to anyone.
My Lord, all the concurrent findings are against the...
We'll see there is more things.
My Lord, may kindly consider.
Next.
This is
Yes, what is the urgency in this matter?
16th appeal.
No urgency.
Obliged.
In this matter, I have paid for early hearing in the matter because earlier it was directed by this honorable court to list the matter in the month of February 2020. But thereafter matter, this is very hard.
Before matter, why should we give it?
They are, my lords may give some date, January, whatever dates subject to lordship's convenience, because they are going to retire.
Lord, the matter was on regular board on 3rd April, my lord. It was taken on 3rd April and directed to be listed after 2 weeks.
State examine.
Lords, May January, February, lords.
Lordship, there is a senior advocate, Mr. Satyanarayana, son VC law. Kindly connect.
Which item?
Item 31.
7 or 31? 31.
You can start, please. Don't wait for him if he is not there.
So kindly pause the war others in some.
May I please, but
Yes, Judge.
it is pertains to the appointment of arbitrator. My case is, the firm has been dissolved by invoking section 43 of the Partnership Act. Once the firm is dissolved, my lord, then arbitration clause cannot be invoked. That apart, my lord, in the first case, my lord, technically, my lord, the respondent has seek for a specific performance of oral agreement, which is also
Arbitrable. All these issues, Mr. Satyanarayan, are arbitrable. You can go and raise before the arbitrator.
Of course, there are two views on that. Whether include the land judge also observe, the land arbitrator can also decide on the dissolution of the firm. There are two views to that matter. Honorable Gujarat High Court held the arbitrator cannot consider issue with regard to dissolution. Whereas Honorable Bombay High Court took a contrary stand. That is also an observation made in the impugned order. That raises some difficulty for me. Whether the dissolution of the firm can be ordered by the arbitrator is also a moot question.
Order and Senate counsel for the petitioners. In view of the fact that most of the issues, that all the issues sought to be raised are arbitrable, we see no ground to interfere with the impugned judgment of the High Court. 22nd September 25 of the High Court, referring to that dispute, interested parties to the arbitrator as per the agreement clause. Discuss.
I oblige.
श्रेय ये बार कौंसिल वाला ऑर्डर क्यों नहीं अपलोड होगा? Okay.
I appear for Noida Authority. I'm so sorry.
Not Noida.
My apologies.
32. Say the petitioner is petition in person. The petitioner will take.
Yes, my lords.
Madam, are you there?
Yes, my lords. I am the petitioner in person in item 32, my lords. I just heard my name. I thought.
You mic in from current.
Yeah.
It's going on. Your matter.
I apologize, my lords. I beg to appear as petitioner in person, my lords. My lords, by way of the present petition, my lords, we have challenged the office order dated 21st of November, wherein, my lords.
First of all, you tell us this matter is pending in the High Court.
Yes, my lords.
It is coming on 11th.
Yes,
Then why are you taking, Madam, multiple chances? Argue before the High Court, get a judgment, whether favor or against, then come to us.
My lords, that was filed, this matter was filed before listing of that particular petition. Apart from that, my lord, just for to expedite the concern, because thereafter.
No, please don't, this amounts to then form shopping, because of you are not getting an interim stay in the High Court, therefore you rush to the Supreme Court.
No, my lord, just because.
Go there, become party, it is not in dispute. The petitioner advocate is in person, has appeared in person. She fairly admits that the same, that the identical issue is pending consideration before the Delhi High Court in a case titled as First Generation Lawyers Association versus Union of India, where the matter is now listed on 11 December 2025. So in this view of the matter, when the High Court is already seized of the matter, in this view of the situation when the High Court is already seized of the matter, we are not inclined to entertain this petition at this stage. The petitioner, if so advised, may join the proceedings pending before the High Court. And, High Court, so we request the High Court to allow the petitioner to assist the court as an intervener. Right? So that if you want to come, it goes without saying that the agreed person by the judgment of the High Court will be at liberty to approach this court in accordance with law.
Obliged, my lords.
In this matter, Lord, I have read your lordship's Lord, directions, detailed judgment. I appear for Noida authorities. Lord, some of the directions are already there, my Lord, already we are complying with. If your lordships can consider having it, my Lord, next week or immediately on the reopening, I can file an affidavit pointing that out.
State has filed, your SIT is seeking more time.
Yes, my lord. We filed 2 reports, one status report of.
Tell them to complete within 2 months or so. They are asking 3 months. Already sufficient time is given.
Yes, my lord. Yes, my lord.
But there's an application for intervention, my lord. There's an application for intervention by a farmer who your lordships were pleased to protect all the farmers in the earlier order. Now the last order, their apprehension is the last order constituting the SIT doesn't mention that protection. So they are worried, my lords, about whether they are to.
We have protected them. SIT will have to find out. Suppose there is a nexus between them and the officers of the Noida.
Yes.
And on account of that, if excess payment has been received,
Yes, my lord.
of course, SIT will not take any action against them because of the entire order. But at least we would like to know that is it by mistake of payment has been made, it is because of collusion that it has gone, or that you are entitled in law therefore payment.
Absolutely.
There can be 3 situations.
Yes, my lord. That may be,
It
but
will not cause any impediment.
But-
SIT will have free hand to examine everything and submit a report to us.
not the coercive step part that your lordships may observe.
That we have already said.
But not in it's not reflected in the last order, and they are getting now calls from the SIT, so they are worried about. That's why they moved it.
No, SIT will look into your accounts, your.
That they will do. My lord, that they are not hiding or shying away from it, my lords. After all, but apart from what your lordship's order was, my lords, of 28/7, it's there in my IE, my lords, all in one place, page 35.
Write down IE number 2.
Only one line, my lord, if your lordship permits. My instructions are every amount paid by way of compensation
by court
is paid as per the determination by competent courts.
That's right.
It's not, my lord, on our own we have increased or anything. But that we will have to place on record. Just to remove any.
No. That we know it. The orders are by the court. But as per the orders of the court that somebody was entitled to or not, and whether your officers were colluding, that part will have to be investigated.
In getting the order of the court.
No, the order is in my case, and you are extending benefit to XYZ.
Correct. Then it's a.
And are you doing it bona fidely with a view to as a part of the welfare organ, or you are doing in collision with them? These are all issues to be investigated.
I thought your lordships have an impression that instead of 100, we on our own gave 200.
No. That is not the case. That you are absolutely right.
Actually, it is a case where under one single notification relating to the same village, all these lands and hundreds of orders have been passed by the High Court and even approved by this court fixing 297. Earlier, the award was only 17 rupees. So therefore, Lord, by virtue of section 28, capital A of the Land Acquisition Act, Lord, if some.
So the 28A, no, well, 28A, everybody will be entitled to, provided that he goes to the reference court. Under 28A, within the time limit.
Necessary, my lord, with respect.
Within the time limit, because there is unfortunately no power to even condone delay under 28A, and anybody can obtain award on the principle of parity. This is one provision I have held in judgment where Article 14 is very clearly reflected.
Right, my lord. Correct.
28A
Yes.
is a legislative philosophy
Intervention.
reflecting Article
Article
14.
Absolutely, my lord.
That was liberal view we have taken.
Yes.
But for that, somebody will have to go to court, to the reference court, obtain an award.
No, the person can
or-
apply to the authority itself, my lord, saying that this order has been done.
If the court authority can extend it or not, that is the point. Or 28, suppose you don't go, there are judgments of this court, there we have invoked 142, granting same compensation. If
Yes.
that is the order, absolutely no difficulty. They have to comply with, they can't run away from the
The
court direction.
SIT, my lord, should specifically examine, my lord, whether the entitlement is based on the principles underlying section 28 and the judgments and observations.
Quite sure that whatever plea will take, but we are expecting SIT to examine the assets of all the chief executive officers and all the officers, law officer, estate officer who have served this Noida for last 10, 15 years.
Yes.
They can expend a little more also. We don't want to say in the open court.
There were in the last, just Mr. Shirodkar's report were 12 officers. That's the SIT that my lords had set up, the Shirodkar committee. And my lords have outlined that in the last order. So in that, they had identified 12 officers. So the third issue, so right now we are looking at
That is for you too. That is the prerogative of the SIT.
But the first question will be entitlement. My lord, are they right in giving the opinion that it's equated?
Entitlement can't be a defense to be pleaded like this. Entitlement is that where the court have held you entitled.
So therefore, I'm saying SIT must examine this question of entitlement, my lord. It's not enough that's.
Of course, we are quite sure they will examine it. Right. IA number 200287 of 2025. The prayer in this application amounts to directing the SIT to the prayer in this application amounts to advising the SIT to direct its investigation in a particular direction. That may not be unadvisable expression of opinion by this court at this stage. Sufficient directions to safeguard the liberty of the beneficiaries of the higher compensation have already been issued. No additional directions are required to be issued, are necessitated at this stage. IA 262363 of 25. The arguments made in this application amounts to the explanation which the petitioner wants to render in his defense. All that we observe is that these facts may be placed before the SIT for their consideration. No direction from this court is required. Next para, main para. Status report dated 26th October 25 by the SIT is taken on record. We appreciate the steps taken so far by it. We hope that the SIT will be able to take the ongoing investigation to a logical conclusion at the earliest. However, in view of the prayer made for extension of time, we grant 2 months additional time to the SIT to conclude the investigation. A fresh status report we filed.
IA number क्या है?
Post the matter on so and so date, interim direction.
At this stage, it is the FIR has not been registered yet. It is inquiry and then FIR. So the 2 months they've sought for the inquiry, to complete the inquiry.
Inquiry liquidity. You people are also seems to be reluctant. Don't invite the. Anyway, first you complete your inquiry and then see.
Lord, would your lordships
Lord,
consider
criminal
permitting Noida to file an affidavit?
Sorry.
We'll place whatever, my lord.
Liberty is granted to Noida to place on record any additional evidence.
Great.
Lord, on behalf of the law officer, I had moved an application. It may be disposed of.
You want to take your defense in through us.
No, Your Lordship, I'm asking.
We have said so, that this is your defense plea, you place it before the SIP.
I'm saying that my application may be disposed of in terms of this order. Grateful.
Grateful.
May it please, my lord. My lord, item 8 is that matter, that student who was arrested for possession of a pistol. Now only the IO remains, all other witnesses have been examined.
IO cross deferred because his lawyer was not available. The last witness was the investigating officer. The cross examination was deferred because the lawyer for the defense was not available. Now it is posted on 17th.
For cross examination?
Yes.
What is the date?
What's monitoring the trial, my lords?
What is the date, Mr. Pasha?
Lordship, the case is that
What is the date next week?
What is the next date?
17th of December.
17th.
So why don't you cross-examine the IO also on that?
Lordship will cross-examine, but Lordship on the last date, Lordship had indicated that now that the trial is almost over, Lordship, the question, this bail has been pending for 2 years. This was this becomes infructuous once the order is pronounced. So Lordship had said that Lordship will hear and consider. He's been in jail now for over 7 years. Most of the offences, he's already served the sentence.
If the trial itself can be concluded in a month or so, if you make the trial time bound,
Jammu and Kashmir.
Lordship, please.
and we keep the question open and liberty with you that in case they don't conclude, then
It's serious of
revive this petition.
giving locations of army camps in Kashmir.
Lordship, there is
No, that's all merits. We will not go into that part.
and all of that is Lordship against a co-accused. The allegation against me in the charge sheet is that I was traveling with the person against whom all the evidence is there. That is
So what we'll do, just see,
Lordship, please.
say, we are informed by Additional Solicitors of India that only one witness, namely the investigating officer, remains to be examined.
His examination in chief is over, cross-examination. before that.
Only cross-examination of one witness, namely the investigating officer, remains, and remains, for which the case is now fixed on 17th December 25.
He is the last witness.
Grand Senior Counsel for the petitioner assures that the defense counsel will cross-examine him on the date fixed.
Lordship, please.
If need be, the trial court will fix another date for the further cross-examination of the above mentioned of the IO within 1 week thereafter. Subject to the right to leave defense evidence by the petitioner or his co-accused, the trial court is directed to conclude the trial proceedings. If you have instructions about defense evidence, then we can give slightly 1 month more time.
Lordship, I'll have to check, Lordship. I don't have instructions.
All right. Can we say then by 28th February?
Very well, Lordship.
Or otherwise we can say 31st January, but that might curtail your.
Very well, Lordship.
By 28th February 2026, in case 26th, the prosecution and the defense counsel both are directed to extend full cooperation to the trial court in this regard. Next paragraph. If for any unforeseen circumstances, the trial proceedings are not concluded by the aforesaid date, the liberty is granted to the petitioner to revive these proceedings.
Very well, Lordship.
But you need not to go, then you can revive these.
Very well, Lordship.
Grateful, Lords.
There are 39 matters which are listed today. There are 39 matters which are listed today. I prepared a chart. Can I just hand over that chart, my lords, to your lordship?
Most of them are on interim bail.
So I'm
38 is to be detagged. Has nothing to do with bail. It's wrongly tagged.
Mr. Raju, these matter because there is already an interim relief.
Yes.
We will take up on some other date.
Yes.
Why we are saying because we have a parted matter. We want to finish that first.
But 38 may be detagged. It has nothing to do with
bail for 6 months now.
9.38 may be detagged. It is a separate petition saying I should not.
Who is at 9.38?
It says that no FIR is made, no course of action to in future. All that can't be heard with the bail application.
No issue. We will take up that matter. But all these matters where there is already an interim bail granted by
For
us.
nearly 6 months, my lord. This 6
Everybody.
months we are on interim bail and there is no allegation against us. So
So we'll hear these matters on maybe in January or so. Because today we are in a hurry to finish parted matter. My both the brothers, their benches are also broken every time only for this matter. So we are keen to conclude that one.
That's fair enough.
Post this matter.
38.
Now, my lords, 9.38 is.
Heard on a separate date.
I have only one request on behalf of the EOW inspector. There are three different scams, three different FIRs. One is the liquor
scam, coal scam,
and minor scam.
My lords,
DMF.
DMF.
Can we have it on separate days? Because and there are about 10 applicants in each matter. If your lordship kindly gives relief to the prosecutors in the matter, so that we don't have to deal with them all in one day.
You want separate dates for these three scams?
For these three cases at least.
Three types.
my lords, this.
Three types of three different districts.
Better to travel from one scam to other on the same day.
Yes, it's very difficult to.
Because accused are common.
Yes.
Yes, ma'am.
Accused are common. So it will help us.
Which is why it won't be possible to deal with each. And we are going to.
If during the course of hearing, if we will experience any difficulty, we will do that.
Yes.
But as of now, it's that the allegations are also overlapping. That by virtue of say one particular position, some minister, some bureaucrat holding, then he or she is alleged to have indulged in this also, in that also.
Correct.
We are going to actually make a statement that some of them say they may continue on bail. So that exercise of segregation of those whose cancellation we want.
Absolutely. What we will do, wherever you feel that yes, now they can continue, there will be no impediment. We will dispose of those matters first. Then remaining matter where you think that yes, you have a kind of a viewpoint to oppose the bail, there we will hear you.
Very well.
My lord, in 9.37 is the only petitioner who is not bail. 9.37.
Also 9.38, no?
It has not been granted into bail.
Excuse me, can I?
First time after.
I am in 9.
Counter has not been filed.
We have not filed.
My lords,
We'll file a counter. Not been able to file the counter yet in this matter.
Which item is referring to?
5.38.
my lords.
38 is different. 38 is different.
In which case?
Navneet Tiwari is
My lords, 9.38 also, my lords.
So can I hand over this chart? Maybe it's easier, my lords, for your lordships to just.
हमारा ऑफिस जैसे फाइल रखता है वो कोई भगवान में नहीं घूम सकता है.
My lords, just have a look at this chart, my lords. Your lordships may have.
And you are talking of this Anil Tuteja.
Navneet Tiwari.
My lords, I am Anil Tuteja.
Navneet Tiwari. So what do you want?
My lord, interim bail has not been granted. Charge sheet has been filed, my lord.
He's the only one who's not on it.
Only one, my lord.
He is the brother of that main accused.
Cousin, my lord.
He's the cousin of Suryakant Tiwari.
So if the main culprit is enjoying interim, he can also enjoy.
No, that's we have not filed a reply. If your lordship wants, please keep it next week if your lordship wants. And we will consider.
We'll keep the same pattern, Mr. Gentleman. Say 9.37. Say London State Council seeks and granted 2 weeks time to file the counter affidavit. Meanwhile, in view of the fact that the main accused has been released on interim bail, the petitioner is also directed to be released on interim bail on the same terms and conditions as have been imposed on the other, on his co-accused.
My lords, in 9.38, if I may just hand over a chart. Now, that is a case where it's a similar relief.
We are first on the bail, interim bail.
I'm exactly seeking that only. I'm in custody
On the
today. in
blanket
another
order of
matter.
bail.
And my lords.
All other.
My lords, may I-
Multiple.
Yes. It's our application. Please let us.
His bail has been rejected by this court, my lord.
My lords,
Liquor.
Please wait. Your turn, please.
Look at this chart. Now in serial number 1 to 5, where the matter is either seized of this court or some orders have been passed, I'm not asking for any relief. But if my lords may come to serial number 6 and thereafter, just pass it there. Now, my lords, I have been in custody for almost 2 years. These matters, these are FIRs, if my lords will notice, of the year 24, where they claim investigation is ongoing. And my apprehension is that for 2 years, Nobody has called for me. They have not asked for my investigation. The minute I am now due to get a bail in those other matters.
So therefore, Madam Meenakshi, you are today, if I remember correctly, I read your petition. You are asking a preemptory direction.
Please, my lord.
That no further FIR should be registered against you, or you should not be further arrested.
I should not be further
in the cases where you are yet to be arrested.
Please, my lord.
But cases are registered.
Yes, my lord.
We will hear it from them. Otherwise, you are in custody on other matters.
My lord, others have got identical relief as in this.
We will
I
hear
am
you.
saying that, my lord,
Any of them is
this
not
matter-
named as an accused.
Only on the basis of anti.
My lord,
Probably no omnibus or sweeping direction can be issued that you should not be arrested in any other case. You will have to make out case one by one in all the cases which have been registered and where you have not been subjected to interrogation.
may I on the preliminary thing just try and satisfy you? If my lords may take this charge.
Not today.
In serial number 6.
Not today, we don't.
My lords, the thing is this, can I just explain? On 15th of December, as per orders passed by a coordinate bench of this honorable court, I will be entitled to move my application for bail before the court, High Court now, because that order comes into effect. So period of investigation there is over. Now, having been in custody for almost 2 years, I do expect, my lords, that my application for bail will be considered at that stage. My lords, I do not want a situation that no sooner that I step out in that matter, I find myself facing these particular FIRs, which are of more than almost 1.5 years, 2 years. I have been in custody for 2 years. Not once have they asked for my lord's remand at any stage while I'm in custody. It cannot, my lords, they can't become an insurance matters like the minute I come out and then I'm sought in for something else.
Apprehension is baseless at this stage, my lord. Apprehension is absolutely.
For a minute with me from 6 onwards. Just please do look at it with me and from serial number 6 onwards. My
If
lords,
your bail matters are pending before the High Court, we can.
my lords, as per the order of this honorable court, they were given 3 months to complete an investigation. That becomes over on the 15th of December. Now, on 15th of December, I become eligible to apply for that bail. I have done almost 2 years by that particular point in time. Now, I do reasonably expect, given what my lords have held in large number of cases, that my bail at that stage should
Please
be.
go to High Court. Each one of them have routed their cases through High Court. Go apply there. If you don't get, then you come.
Apply for anticipatory bail.
also hear from
Apply for anticipatory bail.
From the High Court. We have applied to the High Court.
No, anticipatory bail haven't applied.
My lord,
But
I come
It's
against
a
the judgment.
If you think that we have not seen the brief, madam, you can point out, Meenakshi, you have not gone in before the High Court in most of the cases. That's the whole problem, and that's where I strongly object to. What is the, only because he is a senior bureaucrat, therefore Supreme Court should open for him?
That's not the, that's
Then
not
he
the.
should go first to High Court.
And you should go for anticipatory bail. It
Then
was
may I
for
make the
anticipatory
request
bail.
to the alternative?
We can help
My
you.
lords,
We can request the High Court.
alternative, and that's my alternative thing that I pray.
So,
I submit.
meanwhile, the
My lords, just,
The High Court has said,
my lords,
go
let
and
me just
go
make
and
this
file, take
request in the,
recourse to the
may I
alternate
make a
remedy.
prayer in the alternative, and I bow down to what my lords have said. I
Supreme Court is
submit
not
this.
the alternative.
I have been for 2 years almost inside. They have not asked for my remand. If they want my remand, let them do it within
Where's the question of remand?
1 month or so. And my lords, let it be done with it. It cannot be that the minute I start getting bails in the other, then my remands are sought.
why don't you argue all these things before the High Court? We can't understand.
My lords, I prayed, made the similar relief in the High Court. That's the judgment I'm up against. My lords, the Wajid principle that my lords have enunciated, I'm on the same line.
One after the other.
Otherwise, my lords may keep me on.
All right, thank you very much.
Hear me on
The next matter, item 10.
Just like.
My lords may give me a date then in this matter, my lords. My
Date
lords,
we will give. That date we are giving.
my lords, on this side of the vacation, if my.
No.
My lords are dismissing or
My lords,
tagging.
I'm in a matter of personal liberty. My
Plus, we have to file a reply, my
on
lords.
this side of the vacation.
My lords are detagging it. My lords are detagging it with nothing to do with the bail, my lords.
My lords, that's not, this is matter that goes with the other matters. There is no doubt. We are identically situated as all the others here.
No.
All right, item 10.
My lords may give us a date then sometime early January, please. Then.
The court master will give a date. We'll
Very
upload it.
Great, great.
My 11 is also connected. It may also go, my lords. 11.
11 now.
May it please, ma'am.
11 minutes.
Just a minute.
Lights.
Not 11, 12 and 13, my lords, is connected with this. That's the excise.
11, In item 11, Mr. Raju, there is an IA. We are issuing notice, you file reply to that.
Very well.
IA number 24806 of 25. Issue notice, then Mr. Zoeb can accept notice. Or you are appearing there. You accept notice for the life and we file within 2 weeks.
Mr. A.K. Sharma will accept the notice.
No, it's 12:13 since my learned friends are here.
But I want to bring to a larger.
When we grant the bail, you say you put any condition. The moment you put the condition, they say, no, this condition should not. We'll relax the condition.
I don't mean to interrupt, but 12:13 since my learned friends are here. 12 and 13, item 12 and 13.
Conditions are by the trial court. They could have moved the trial.
Not the condition.
13 minutes.
12 and 13 are.
12 and
Mantri ji.
Yes. So I'm praying since they are all
Only
in
50
interim
lakh per
bail.
day.
They are all in interim.
No, my lord, on this,
They are all in interim bail. So let them also be.
I filed my reply. Your lordship asked for a status report in this matter. We have filed the status report. Your lordship may see the status report. It was filed yesterday, prior today. Unfortunately, it couldn't come on. We filed it at 11:10, but it's not been before your lordship. Lordship, if he wants to press it urgently, keep it next week.
You have filed
a status report.
Status. Your lordship asked for a status report. I'll read your lordship's order.
We are informed by.
Right, so far as item 13 is concerned, I got something to say, my lord. So lordship, kindly permit me. Item 13, but is for regular bail. He has been in jail, man, old man. 1 year he has been in jail. All the others have been granted interim bail. This man also be pleased to grant interim bail for him. So
He is an old but strong man. So we can wait for a couple of days.
In item 12 and 13.
SD Sanjay is appearing. He is not available today. Lordship may keep it next week.
Because I'm praying, my lords, lordship may detach this and keep it next week, my lords, as far as this is.
Item 12 and 13, item 12 में लिखना Mr. Mahesh Jetmalani, Senior Counsel appearing for the state of Chhattisgarh, state that a status report was filed, but the same is not on record. Registry directed to tag the same with the paper book. Item 13, you have filed counter
Same person.
Status report, Minister have asked us to file an additional affidavit.
I need the order. Status, your lordships wanted the status of the investigation, details of the witnesses' documents on the record examined so far, details of the proposed investigation qua the petitioner, which is still pending, and detailed timeline for investigation.
That's in 12.
All of that we have put. That's in 12.
That's it. 13 is ED. Of the
13
same
is
person,
based on
ED, same offense, same predicate offense is ED.
So 12 and 13, same date.
Because can I pray for a date, Milos, that I know the date will come in the order, Milos, when it.
We are giving the date, Mr. Dave. Please leave something for the court staff also.
I know, Milos, I was only praying that it can be.
No, this side. No question of.
He will finish 10 months in custody.
Sorry, thank you.
As far as
Thank you very much. Thank you. Wait for
10
the
months for some 68, 67-year-old man in harsh winter, Milos, your lordships may consider.
Yes, thank you very much. Thank you.
13 minutes, they have not filed the status report. Let them file it in the meanwhile, in item 13.
They are filing, that's why, and they can't file without giving an advance.
They have filed, 13 they have not filed.
Mr. Dave, you know how to go. You teach, you tell your client.
Milos, ED, there's no status report order for ED, Milos, let it not be there.
You can also, maybe you can, it will help you also.
No, it will not help. It cannot help me, Milos. None of the, I expect no help from the state.
Give him also a copy of this status report.
I have helped him in 1 or 2 matters.
Oh, never. Mr. Jetmalani never helps. He helps outside, but not here inside court.
What is outside?
You have to make the choice of the time when you ask.
That's why I said, Milord. Your lordship, I bow down to what has fallen, Milord.
No, he never said. He is very fair counsel. I will provide the documents.
Whenever I said anything against anyone, for me, everyone is fair. I am the most unfair person. In my unfairness, can I request next week, my lords?
No, not next week.
All right.
All these matters will have to be had together.
Please keep this separate. They are all on interim bail, my lords. It will get flooded by those matters.
No, it's not miscellaneous week. That's why we are so.
It's a miscellaneous week.
No, it can't be miscellaneous week. We are in under a lot of stress to complete arguments in some of the parted matters, which are going from last 2-3 months, in fact. Because ultimately, what will happen when you start forgetting the real issues, and then you keep on looking for the pleadings, try to find out and create problem.
But my lord, since I have been here, and I've been here for almost 30 years, closing winter was never a miscellaneous week. Only the reopening was this miscellaneous.
It creates problems, sir.
Let it come.
And then we need some homework for the vacations.
Yes, absolutely.
We want to create.
So let the reopening work be miscellaneous.
Yes, we will do that.
Oblige, my lord. Sorry, my lord.
Oblige.
Your lordship, kindly pass over the matters. Pass over.
Pass over means then we are not taking up today. List on so and so. Next week, bail matters.
Yeah, please.
सबको दे दिया बोलना।
Lords, I'm appealing.
तुम चाहे करो।
The first year. Yes, yes.
May I please, my lords?
Yes, my lords.
My lords had directed us to file the counter, my lords. So we have filed the counter. My lords, it's a unique case where there is an allegation of rape, my lords, on the father-in-law. But my lords may see the evidences, the statement.
The problem is that if you will see the order of 15th October,
My lords.
Just see the order of 15th October.
My lords.
We are also very, very skeptical about these matters, and one, at least I'm very conservative. Normally, there's no question of
I'm aware.
being like this if this happens.
Yeah.
But look at all the briefly facts we have noticed. The daughter-in-law along with her husband appeared online.
No, my lords.
Counsel for the party. In reference to the statement said to have been made by the complainant, prosecuted on 29th October 2025 before the judicial magistrate first class,
Not down. I have it.
has also been made. Taking into consideration all the attending circumstances, leave grant to we allow this appeal. Set aside the impugned order of the High Court dated 25th September 2025 and admit the appellant to bail during pendency of the trial, subject to the bail bonds already furnished by him before the competent court, and subject to the further condition that he shall continue to appear and will fully cooperate with the ongoing with the trial.
Lords, he should join the investigation because earlier he was absconding before my lords had given him the protection. My lords.
Already joined.
So he should join investigation
He
and
has joined.
cooperate as and when.
My
my
lords,
lords,
he
is
has-
caught.
He has joined. It has come.
And fully cooperate with the investigation as a criminal. In case any charge sheet is filed, the appellant shall also cooperate with the charge.
My lords, charge sheet has been filed in the matter, and after that my medical examination happened, and in my medical examination it came that I'm incapable.
It's all right, these are all matter of trial. Can't comment on these things. Take the order.
My lords, Highly obliged. Highly
Grateful,
obliged.
madam.
Highly obliged.
Lordship may kindly take item 15.1 and 15.2.
Madam, if I let us start now.
Please, Your Lordship.
Let us start now these matters.
Yes, Your Lordships, actually,
Yeah,
there's
okay.
only a very short
Trying hard.
element that is left for Your Lordships to consider. Because as far as the main relief is concerned, it has been given, only the implementation has not been done in the correct manner, Your Lordships. And that is what we are aggrieved by. Give the list of dates. And Your Lordships, I will not repeat what has already been contested in this
You are also in the Air Force battle now.
Air Force.
How many other consul are left in the Air Force?
Pilots, I am for.
You had already argued,
No, I have not pilots, I argued Navy.
or maybe that your arguments are omnibus. We thought you have covered Air Force also.
No, my lords, I have not. I'm representing two male officers.
For like 10 minutes?
I'll take 10 minutes, 10 to 12 minutes.
Lordships, I will not repeat any of the arguments Lordships
That's it.
already heard with regard to the QR, with regard to the fact how we were not being assessed in the clearest of the intent, your Lordships, because first of all, many of us were pregnant during our assessment period. Secondly, the QR kept on changing, your Lordships. And Ms. Guruswamy has already explained to your Lordships all the adverse circumstances with regard to our assessment, your Lordships. So I'm not going to readdress all those points. The point that is coming up before your Lordships is 3 points. Your Lordships will kindly just take my MA, which is 1799 of 2023, 15.1. And I'll take your Lordship to the prayer that has been made in this. At page 12. Lordships will see that the prayers that I've made.
No, but in your note, you must have mentioned it.
Please, your Lordship.
In your brief submission note,
Yes, your Lordship.
you must have mentioned all these things.
Your Lordships, the prayers are not there, but I need to show 2 orders and the prayer. Now, your Lordships had ordered that I shall be deemed to have had permanent commission. I would have been deemed to have 20 years of service, and all incremental and promotionary benefits would have been deemed to have given to me. I'll just show that order to your Lordships. However, they have given me pension on the actual service which I had served in the service, which was about 11 or 14 years, depending on what I was.
Your claim is only for pension.
Also, your Lordships deemed permanent commission. I'm not giving that up, but I'm adopting Ms. Guruswamy's arguments on that because I don't want to duplicate that, your Lordships. But with regard to pension, I have a stronger point. If your Lordships comes to page 39, in an earlier round after the High Court, this Honorable Court, your Lordships, had granted me these reliefs. At page 39. All women SSCOs governed by the present batch of cases shall be considered for grant of one-time pensionary benefits on the basis that they've completed. Page 39, your Lordships. This is the order in the case of Wing Commander Tayaba, which starts at page 15. Lordship has it? I'm sorry.
Yes, there is some problem with the pagination.
Internal page 25 of the judgment.
Yes.
Please.
All women SSCOs.
Yes, your Lordships. Grateful. All the women SSCOs governed by the present batch of cases shall be considered for grant of one-time pensionary benefits on the basis that they have completed minimum qualifying service required for pension. Cases of appellant shall be evaluated on basis of HRP dated 19th November 2010. And third is important, officers who were found eligible for grant of pensionary benefits in terms of present direction shall not be entitled to arrears of salary, but arrears of pension shall be payable with effect from the date on which the officers are deemed to have completed 20 years of service. We also clarify that we have dismissed several other petitions after considerable degree of delay following their release from service. I'm not in that category. And finally, your Lordships, in the present batch of cases, there are 3 officers who have scored QRs between 6.29 and 6.41. The cases of these officers shall be considered sympathetically by Air Force authorities on the same footing. Now, in your Lordships, what they have done, when we went to them, they have, your Lordships, not given me the deemed 20 years. Which would have included a timescale promotion to the post of a wing commander. And my pension is being calculated on my actual date of discharge, which varies from 11 years to 14 years.
Yes.
And 2 persons, this was a list of 32 persons, your lordships. The reply of the government very clearly says that we are all entitled to it, except for 2 persons whose QR was less than 6.50. And their QR also, your lordships, one lady's QR is 6.49. And that QR, your lordships will find in their counter affidavit. If your lordship sees their counter affidavit,
Why don't you stick to your note? Madam Viva? We don't want to go into all these files. That's why we have requested everyone to prepare a note and.
that's a list of date, but these points which have been given by them in the counter, your lordships.
So we have understood that part. Yes, you can point out. Basically, your MA is execution of this order.
Yes, your lordship. So
Your MA is basically an execution application of number 1622 judgment.
Please, your lordships.
Right?
And thereafter, your lordships, there's another order which has been passed, which again reaffirmed this, your lordships. And lordships may kindly take note of that order.
Serial number?
Your lordships, it's the order which is dated. Lordships will give me a moment. Fifteen 4/2024.
Serial number 18, your note.
Yes, your lordships. Which Ms. Dhara had argued actually. So your lordships, there it has been clarified that all increments have to be given. And if I can just read this for a moment, your lordships, this order, lordships may not open the file, I'll just read the relevant portion. Your lordships, one of the paragraphs is para 5. During the course of hearing, it has emerged before the court that the women officers were released from service at the end of 14th year and salary for purpose of computing the pension was taken as last drawn salary on the date of release. No increments have been granted to applicants between date of release and date on which they are deemed to have completed 20 years of service in terms of judgment of this court dated 16th November 22. And then your lordships, at para 11, clarification is given on the issues of computation of commuted value of pensionary payment, encashment of annual leave, and grant of ECHS benefit. So all these have been granted, your lordships, vide this order. And therefore, your lordships, in their reply, I'm just pointing out to their reply again, your lordships, is for the reason that they say that these 2 ladies did not have the QR. And secondly, that we cannot give them all these benefits on a deemed basis because they have worked only till 11 years or 14 years, your lordships. Now, these orders, and we were parties. The main thing that I want to put before your lordships is that in these matters, we were petitioners, your lordships. All of us were petitioners, which they have admitted in their counter again. So the benefit, your lordships, by 2 affirmations have been given to us, your lordships, but they have not flowed to us. And this is the only thing that we want to put before your lordships, that besides considering us deemed permanent commission, because of the problem that we have faced in the QR.
Was there any formal order passed rejecting your claim?
Please, your lordship.
Was there any formal order passed?
Yes, your lordship.
Rejecting your claim to the extent of its entirety? Partially they have accepted.
Yes, your lordship.
Partially they have granted.
There's no formal order, but we were in High Court. Then we came to your lordships. As per, we went to the High Court claiming that when we were not receiving the benefit.
That is the initial part.
Yes.
Now, when they pass the order, say for granting you pension only for the short service commission service.
Please, your lordships.
So they restrict your benefit only for that actual service.
Please, your lordship.
At that time also, they must have issued some pension order, some people.
Yes, lordships. That's the service chart that they
will not challenge that order. Part of that.
Your Lordships, that's a part of the whole record. My service record has been quoted. There's no formal
Challenge
order.
that order through a MA.
Your Lordships, there's no formal order which has denied me, but there is my service record which has been cited for me. And your Lordships will see page 43.
No, but in all fairness, should you not have gone to AFT?
Your Lordships, we went to the High Court. High Court passed orders. After that, we came in SLP before your Lordships.
No, that was in 2022.
Yes, your Lordships.
SLP allowed in your favor in a way.
Yes, your Lordships.
Directions are issued at page 25.
Please, your Lordships.
ABCD direction.
Your Lordships, this was after Babita Punya when the implementation
Right.
was to be through AFT. It's after all that, your Lordships.
Eventually, the directions issued on November 2022,
Please, your Lordships.
they have, according to them, construed, according to you, misconstrued,
Yes, your Lordships.
granting you partial relief.
Yes, your Lordships.
So that to the extent they denied the relief,
Yes, your Lordship.
or to the extent you claim yourself to be entitled to,
Please, your
did
Lordship.
you approach the AFT again?
Your Lordships, we were in the High Court and we were all parties in that petition. This is MA in my own SLP. This was originally my own SLP.
That's why, madam, why we are also wanting to know that you are claiming the relief
Your Lordships,
to an MA in a
we
decided
went
case.
directly to the High Court. We did not go to AFT.
You didn't go.
We did not go to AFT. We went directly to the High Court. And thereafter, Lordships, after the impugned order of the High Court has passed this order.
Now, what is the date of the High Court order?
Your Lordships, that is dated. What is the date of the High Court order? 11/8/2011?
Yes.
11/8/2011, Your Lordships.
So that was before 2022 judgment. Against that, you came to this court. Your appeal is allowed.
Yes, Your Lordships.
Your appeal is allowed.
Please. Your
Directions at page 25 are issued.
Yes,
So the High Court judgment becomes meaningless because that judgment has been set aside.
Absolutely, Your Lordships.
Now, in perpetual compliance of that judgment of this court,
Yes, Your Lordship.
they have issued some order granting you partial relief, declining you the remaining one,
Please, Your
for
Lordship.
which now you are before us.
Please, Your
So
Lordship.
the only form which you have chosen to claim the denied relief is an MA in a decided civil appeal.
Your Lordships, because the order became final as far as I am concerned. Against that, Your Lordships have not even given me the permission to go to AFT. So today I'm closed from going to AFT in any case, because this is Lordship's own order. So AFT will not be implementing it, Your Lordships, because preferentially I should have filed a contempt. In fact, I should have filed a contempt.
You have 2-3 options. One, to go to AFT, challenging that part of the order.
Please, Your
Second, probably you could file an execution petition saying that in terms of this judgment, you are entitled to so and so relief, which have been partly granted. And third, maybe if you find that this is a willful or deliberate inaction on their part, then you could initiate contempt also.
Your Lordships, there's only one distinction I want to make is because as far as the willful part is concerned, some of other petitioners have been given, but we have not been given, Your Lordships. That is the difficulty that we are facing, and that's why we are before Your Lordships, because they have unequally followed the order. And in the same situation.
If we understand your relief,
yes,
you are saying that instead of granting pensionary benefits based upon
yes,
your actual service rendered in the SSE,
yes,
you should be first assigned a deemed date of permanent commission,
yes, Your Lordships.
right?
Please.
And that will happen only, and after that, you should be granted pensionary benefits based upon the deemed length of service.
Yes, Your Lordship. So deemed length has been taken as 20 years. Lordships have granted that, which was the relief.
In SSE, you are served for 14 years or more.
Your Lordships, one batch has served 11 years. They did not get the next 4-year extension, and one batch served 14 years.
No, before us, only 2 officers are there in your application.
Your Lordships, there are 2 applications, 15.1 and 15.2. So,
in one batch, 11 years.
We have nine of us left, Your Lordships. We are
In
9.
one batch, you are 11 years.
Yes.
And in the other, 14 years.
Yes, Your Lordships.
14 years. And,
One is, yes. One
and
is
if you were to be granted permanent commission,
yes, sir.
then it would have been 20 years.
Yes, Your Lordships. And if Your Lordships will see the chart for a moment, which they have themselves annexed, where they have said that 5 people have been granted. What page is that chart you were showing me yesterday? Page A2, page 41, if your lordship sees. No, wing commander, just let her. Wing commander. No. Where is that chart? Lordships will come to page 46. This is the letter of the Air HQ. So your lordships will see serial number 1 to 5 are given the deemed timescale promotion to wing commander. And this is a timescale promotion. If your lordships has page 46.
No, we are not required to go anywhere except you come to your note and come to serial number 18, 19 and 20. That's all.
Yes, your lordships. 18, your lordships, is my application before you.
Right? Seeking the following clarification. This is the now relief and MA.
Yes, your lordships.
The pensionary benefits would have to be computed on the basis of salary on the date of deemed completion of 20 years, right? As we were also pointing out.
Yes, your lordships.
Then
notional increments, your lordships.
notional increments, obviously, from 14 to 20 or 11 to 20.
Yes, your
if that is granted, then you
My
claim that's
notional
not actual salary, but notional pay fixation.
But
Right?
the lordships would then continue.
And then consequential release of the
Yes, sir. Because
now come to para 19 is their defense.
yes, your lordship.
So you have to simply respond to that. Rest is all history.
Yes, your lordships. So their only defense is that only 2 people did not have the QR. And they don't qualify, which lordships in their judgment had said, please consider them sympathetically because they are only 0.1 less or 0.5 less. Your lordships will see that table. It is
6.49 and 6.24.
6.24. So earlier,
what was the minimum benchmark?
Your lordship 6.5.
Huh?
6.5. Benchmark is 6.5. And we all had 6.5 except these 2 unfortunate ladies who were probably in the family way at that time.
Have you said anywhere in the affidavit?
Yes, your lordships, we've said it. If your lordship sees, there is a note that we have filed, your lordships. Written note before your lordships. And I've said, your lordships, that and your lordships, with regard to this lady, I've also said it is also pertinent to state that it is a matter of record that she was a decorated officer who had served Air Force for 11 years and was ranked 1st in academics and 3rd in order of merit in her course. And she also pointed out several extenuating circumstances such as her pregnancy during the time of assessment, casual marking of ACRs and other overarching factors during the relevant point of time for truncating. I've put it all on record, your lordships.
All right. Anything else?
That's all, your lordships. And therefore, your lordships, I'm praying for your lordships' indulgence because we have now been waiting almost for a very long time, your lordships. Therefore, for us to go back to AFT at this point of time will be another...
No, that will be unfair to both sides to ask you to go back.
Your lordships, for us, we are now retired, so to speak. We are not doing anything else.
Basically, your claim is to be considered only for deemed
only for that.
permanency and consequential
And
pension.
relief has already been granted to me. And I pointed out the second order to your lordships, where the same increment has been granted to 5 ladies as has not been granted to me. I just pointed out that order to your lordships.
All right, thank you.
Grateful.
Please, Baba.
Your lordship will recall, my lords, in 15.1 and 15.2, last week, Senior Counsel Mr. Ahmadi argued, and we also circulated a note, my lords. Because in 15.1 and 15.2 last week, Senior Counsel Mr. Ahmadi argued in detail, and we also circulated a note, my lords.
Yes,
it is there on record, my lords.
Right.
Yes.
Manoj, in item 15, I beg to appear in two IAs in 142841 and 142848. I've been led by Mr. Sanjay Ghosh. He's on the VC, if he may be unmuted. The court master may kindly unmute him.
You can argue what you like.
Yes, my lords.
No, sir, unmute yourself.
Because what we are hearing is all deemed fiction. So we cannot deem fiction, hear him through you.
I'm grateful for the opportunity, my lords. My lords, I'm on the similar foothold as Kavita Bhati, if my lords may remember. My lords, I'm a serving officer. I've sat
Right now we are serving, right?
I'm right now serving. My retirement date is 28th of December. My lords, I've sat for 3 board of officers. My last BO was, the result was out on 22nd of May 2025.
Have you got PC?
No, my lords.
Even after
I haven't
20 years?
been impeded in this matter yet.
No. Are you continuing by virtue of some entire order of the court?
No, my lords. My retirement was of 28th of December. I'm still a serving officer.
No, serving officer is fine. Are you still a short service commission?
I'm still a short service commission officer.
Then how they have allowed you to continue 20 years without making?
No, my lords, I'm on my 15th year, 14th year, right? 14th year.
14th year.
Yes, my lords.
So that means virtually last year.
Last year, my lords, I retired on 28th of December.
28th
of December this year.
December. All right.
I'm only seeking impediment, my lords, to this. I have all the prerequisites. I have maintained my CGPA. My fitness level is A4G1. And
have you given any note of conveyance compilation or anything? Any short note of your claim?
My lords, if my lords will allow me, I can give a short.
You can give us.
I have my applications are.
Prayer must be only to grant you PC.
Yes, my lords.
Consider you to grant for PC.
Yes, my lords.
Did you go to AFT?
My lords, no, my lords, because this court was already seized of the matter.
That is the problem. Everybody comes straight direct. So you have filed an MA for granting all this relief. It was
My lords, my result came on 22nd of May. And I moved this court in June because this court was already seized of the matter.
But actually, we want to be clear about it. That
Please, my lords.
Whenever your result came and you were not taken into PC,
yes,
then you have filed an application.
Because this court was already seized of the matters, we had filed an application.
We are not asking for the explanation. We are only asking fact, please.
Yes, my lords. An impediment.
You have filed an application for impediment only.
Yes, my lords.
Impediment as petitioner.
Before this court.
Before us, you want to be impleaded as a petitioner.
Yes, my lords.
Were you party in the earlier proceedings?
No, my lords.
Young man, what please?
My lords, because in Kavita Bhati and Nikita Pandey, my lords had allowed the same impediment application on the same grounds. Therefore, we were of the opinion that
you have not filed any case before High Court or before the Supreme Court or before AFT. All below your standard, directly Supreme Court MA.
I bow down, my lords. My lords, the only.
All right. You are seeking a direction for PC. Then to continue till 20.
Yes, my lord.
And then grant consequential penalty.
The same protection that the my lords have given the other officers.
All right, thank you. Anything else you want to add?
That's it, my.
Anything else you want to add? You have been denied PC again on the basis of benchmark.
Yes, my lords, there was not enough vacancies. The vacancies were never told to us. We are in the logistics branch. We head the logistics branch at a forward base.
No, you are denied PC.
We were denied
on account of being your failure to achieve the minimum benchmark or on account of non-availability of it.
We had achieved all the prerequisite benchmarks. The CAT C we had achieved. The health categorization of A4G1 we had received. The CGPA of 6.5 to 7 we have average maintained. But still we were not allowed. We were not considered for PC. We were considered but denied. In all three boards. We were, my lords, a part of Balakot. We were a part of Sindoor. We take care of the entire logistics of a forward Air Force base.
What is your
And
MA
no
number?
reasons have been given for denial of PC, my lords.
What is your MA number? See, these are going
That's
to
142841.
Reputation will have to deal with.
My lords, 142841 and 142848. No notice has been issued, my lords.
Who is appearing for the?
Yeah. Do you have any idea of this?
Do you have any idea about these? I mean,
My lord, this is an IA for improvement. We don't believe that he's been served with a copy.
Not in RIA. Not in RIA.
Have you not served that?
No, no.
Been served.
Plus, we have not been impleaded yet, so the notice has not been issued.
you have not been implemented because your MA no notice has been issued so far.
Yes, my lord.
And you never pointed out anything.
Right, my lord.
You have been denied because of lack of sanction posts or what?
Whereas the ACIs are a confidential document, we're not aware. All the other prerequisites we have maintained.
This is only one officer.
Whereas the reason for denial has never been given to any officer.
Any other officer?
This is application is by only one officer.
Yes, by only one officer, namely Mrs. Wing Commander Ranu Tripathi. And similarly,
about it.
Well, by order date 16th of June, a stay has already been granted to her batchmates in Kavita Bhati's matter.
Are you continuing service or no? Is there any interim order? No. In your favor?
No, no interim in our favor.
Therefore, you are out of service or you are out of?
We are seeking an interim protection, my lord.
She there till 28th December. December tak.
We are still serving. We're still serving till 28th of December.
So in the MA issue notice, then so and sorts of notice. Please, for God's sake, give copies to right now.
We will. We have served them a copy. We'll serve them again.
Let the paper book of both the MAs be handed over to Land Additional Solicitor in the office of Land Additional Solicitor of India. Madam Kali during the course of day. During the course of day, the reply can be filed. In fact, if you don't want to file reply, it's all right. You can simply, on a statement, you can point out because only one officer. The respondents may either file a short affidavit or submit a statement on facts explaining the claim of the applicant petitioner. Is it correct you ask the officers if other batch mates are continuing? Of this some girl, Ranu Tripathi.
I'm Group Captain Bundela, sir. And during Op Sindoor, when the interim stay of the army officers was ordered, similarly, Wing Commander Nikita and Kavita Bhati approached the court
because of that.
Similar lines. And now she's approached on a similar lines as to stay for the release. That is the whole case here.
Mr. Officer, can she be also allowed to continue for a month or so? Meanwhile, we'll decide all these cases.
As you said, as you order, sir.
Meanwhile, say in view of the fact that the applicant's batchmates are continuing pursuant to the interim direction issued by this court, let the petitioner be also not relieved till further order. We'll decide meanwhile, we are at the back end of the arguments.
So
we'll decide. Just make sure that your applications are supplied to. Even after filing, you are sitting silent, you are waiting for your turn to come. What a great assistance. Madam Pooja?
Yes, may I please, my lord?
10 minutes.
Yes, Manus. Manus, this is 15.8. This is a civil appeal filed by two officers, two male officers who were of the 1998 batch. Manus, at the time when they were inducted, the male officers, so there was they said that the male officers were supposed to get considered for PC. However, in 2006, one policy came which said, because in view of the fact that Babita Punia was filed, so Air Force came up with will not even consider the male officers for the PC in 2006. So this was applied retrospectively on us, and we were also not considered. And after finishing 11 years of service in 2009, since we did not see any career prospects, we were released from services after 11 years. My lords, now what happened in the meanwhile? In fact, Miss Makhija's clients also, whom she was just representing, are my batchmates. They are women officers who were my batchmates. They also were released from service in 2009. All of us were released from service in 2009. In the meanwhile, Babita Punia judgment came. We went to AFT immediately. After Babita Punia, they went to High Court. But we were out of service. Now, what happened, my lords? The matter was pending in Supreme Court. In the meanwhile, my junior officer, male officer, one Lalit Kumar Tandon, who was my junior officer, who was still in service, also went to AFT. And in 2011, I'll just show that judgment. I'll just give, it's a double whammy which I have been subjected to. So my junior, who was in service, who went and he said that I am a male officer, I have been discriminated. If women officers are considered for PC, even I should be considered for PC. He was in service at that point of time. He was allowed, and they said, no, this will be discrimination. Why male officers should be? And the male officers were also considered for permanent commission. Whereas when our petitions came, they said, oh, you are of the same batch as the Madam Makhija's clients, and those matters are pending in Supreme Court. So we will put your case in cold storage. So finally, AU Tayyaba was decided in 2022. Now, my batchmates were considered for PC. Some of them were granted PC. Some of them were not meeting the criteria. So they were given deemed PC as well as the pension. However, when the matter came up before the learned AFT, they rejected. They said, no, your case is not pari-materia to those officers. In fact, I can show that bit by bit, our cases were entirely similar. And that is all we are seeking, that we should also be considered the same way that our batchmates were considered.
Basically, your claim is of parity.
Yes, my lords. It's of parity that we should have been considered, we should be considered, or in the alternative, even we should be given.
No,
we have been.
They have considered, but according to them, you failed to make the benchmark.
No, my lords, we were not considered after in 2009, after 2009, when we were released in service, we were never considered. We were not considered. That is what our grievance is. We were not even considered.
No, 2009. Now, when were you relieved?
2009, my lords.
2009.
And we have been in court since then. We have been in fact, my learned friend has argued in this matter in AFT. So this matter was just lying in the cold storage because they kept on saying that your batchmates' cases are pending. In fact, the Miss Makhija's clients are my batchmates. So they were all out of service, but they have got the deemed PC as well as the pension. But yeah. In fact, Air Force made a statement before the Armed Force Tribe that these people, these cases should not be decided because their batchmates' cases are pending, and these are similar cases. So you should await the Supreme Court judgment.
Have you prepared any one-page note for
Yes,
them?
my lords. In fact, if my lords may come to the last page, page 3 of the note. I've made a short table there, my lords. This is the appellants and women officers in Neetu Thaplial tagged with AU Tayaba. Neetu Thaplial was my batchmate. So that was just being represented by Miss Makija. If my lords may see, date of commissioning 98, date of release 2009, total years of service 11 years, first extension same, consideration for PC, considered for PC in 2004 but only granted, but not considered for PC because at that time women officers were not considered. I was supposed to be considered, but because of the policy, I was not considered for the second time. They said even male officers will not be considered. Moved to court AFT 2011 and they moved into High Court.
How many officers are there in this?
Minus 2 officers.
2. You have given particulars of only 1.
Malos and another squadron leader Neeraj Kumar and another.
Neeraj Kumar and other you?
My lords, it's
what is the name of the
squadron leader Anurag Sharma. And my lords, even for women officers, the judgment came.
So yours is a reversal jurisprudence.
Yes, my lords.
You want parity with female officers.
Yes, my lords. Yes, my lords.
They have been fighting.
The whole order will.
They have been fighting all through 20 years before different forms, courts, and still, according to them, they are eagerly looking for that date of parity to come.
Yes.
Meanwhile, you have started attacking them.
In Navy also, like I argued, there are times when even male officers are discriminated because they don't want to give PC to women officers. That is why that policy in 2006 also came, and they applied it retrospectively, which could not have been done. And which in Lalit Kumar Tandon case, they have said that the policy could not have been applied retrospectively.
And they served how long?
My lords?
They served how long in
11 years, my lords.
11 years.
Same as the women counterparts who have got the PC as well as the pension. We are exactly the same.
Women officers, because they fought for their right.
My lords, even we went exactly, if my lords may see, they also went to High Court in 2011 and we went to AFT in 2011. Our cases were pending before the Learned Armed Force Tribunal since 2011. It's not that we were not fighting for our rights.
All right.
Obliged.
Anyone else from petitioner side? That your junior just pointed out. For the separate notice there.
15.1 and 15.2, I did not composite note. For 15.2, I'll just give a supplementary. It was 2 points. And your worship, I believe, asked my representative that why did you, whether you are approached me. Now, as far as judicial is concerned, that is a direction of your worship given personal to far and to one part. So therefore, the AFC will not have that. That's why even I know.
So, Madam Asurya, finally your turn has come.
I am always running late, my lords, but
no, you are
sorry.
You are
2.7 is at par with 15 minutes. They were all together in 15 minutes.
All right, thank you very much. Thank you.
Well, I'll request your lordships to take up the written submissions that we had filed earlier. And there is a second compilation that we are carrying today, my lords.
The Air Force?
Air Force, my lords. Ma'am, yeah. Other sides. Fine. My lords, before I take your lordships to this, my lords, permit me to give a little overview of the Air Force again, my lords. If your lordships will take the compilation that I've handed over now, your lordships will see that Air Force has, my lords, 8 branches and divided into some streams. These 8 branches, my lords, flying, aeronautical, administration, education, logistics, accounts, weapon system, medical and dental. So your lordships are only concerned, my lords, in this batch of petitions. There are officers from the ground duty, my lords, which is apart from the flying branch and the medical and dental, which has a separate system. Medical and dental has had permanent commission from the beginning, my lords. So there are no flying branch officers before your lordships. These are all ground duty officers.
Actually, there is no flying.
There is no flying branch officer before your lordships. Flying branch, my lords, has a slightly separate dispensation. In fact, their policy is also different. So that, and I'll give the background, my lords.
They are probably the fighter officers.
My lords, flying could be flying the transport planes, fighter planes,
yes,
helicopters.
sometimes for logistic support
Please,
and
my
all
lord.
these things.
Please, my lord. There are combat helicopters, there are transport helicopters. So, my lords, flying will include everyone who's in the, and navigation is also included in flying, my lords. So, your lordships will see flying branch has the fighter stream, transport stream, helicopter stream, and navigation on the right side. So, these are the 4 streams in the flying branch, my lords. And rest, my lords, are all ground duties.
This aeronautical engineering, there are cases with us?
Yes, my lords. But large numbers are, my lords, education, logistics. In fact, the officers that we have made a list of, your lordships will find that. Page 10 of this compilation is a chart of all the 11 officers before your lordships. This is apart from the IA, my lords. IA, I will have to deal with slightly differently, my lords, because in IA.
Where are the brief particulars of those 11?
Page 10 of this compilation, my lords.
I see that para 14.2.
No, my lords, this chart at page 10, my lords. Your lordships have the chart at page 10.
Page 10, yes. Sucheta,
So, my lords, for example, Wing Commander Sucheta, she's an education officer, commissioned in 2007, released in June 2021. She was considered, so Air Force has a system of consideration for 3 options. Air Force gives 3 options.
Well, Surya.
Yes, my lord.
Subject to your, unless you have very, very strong opposition.
Yes, my lord.
The serial number 9, because her batchmate are extended, we have said we are in the almost in the verge of deciding the cases.
Yes, my
So
lord.
we have asked you to allow her to continue for.
My lords, anyways, your lordships, interim orders are inuring to the benefit of all officers. There are 50 odd officers. They have gone to AFT also. They are
extended to all of them.
Yes, so your lordships have specifically said that it extends to all officers, whether in this court or Armed Forces Tribunal or any other court.
Oh, then no difficulty.
Therefore, there is, in fact, we are the ones who are requesting your lordships that because your lordships have now seen the 3 forces, my lords. And your lordships will see what is really.
Our endeavor is that we are able to decide the cases itself.
Please,
that's why we are.
No, my lords, I bow down. Once your lordships passed an interim order, we are duty bound to comply with that, and we are complying with that, my lords.
Thank you. Thank you.
My lords.
So these are 9, 10, 11 officers.
Yes, my lords.
Last these were 2 main officers which Pooja was arguing about.
Yes, my lords. Last 2 are the gentlemen officers. My lords, so your lordships will see, for example, the first one, my lords, Commander Sucheta, education. So 3 chances. My lords, before your lordships take this, may I just give a little bit of overview, my lords, for the Indian Air Force. So your lordships have seen that there are 8 streams, my lords. Now, Indian Air Force has had the system like the others. So similarity with Army and Navy is that there was an ad hoc system of taking on short service commission on the need base.
Those who are in education,
yes,
that means they are working basically as teachers.
Instructors, yes, my lords. Instructors, my lords.
Instructors for
For officers, my lords, for different courses. Some of our instructors also, my lords, train foreign defense forces, my lords.
Are they subjected to field duties sometimes also? No.
Yes, my lords, they have different duties. So, for example, 2 of the officers who are briefing me today are pilots, my lords, but they are on ADAM duties. So they will be shifted, my lords, depending on what is
Field and operational duties, no. No operational duty.
Yes, my lords. Yes, my lords. In fact, Indian Air Force, your lordships will find they, my lords, it's called the most gender neutral of the 3
You
defense.
call them as education wing.
I'm sorry, my lords?
You have captured them as education wing.
Yes, my lords.
But if they are basically instructors,
yes, my lords.
that means they are also technocrats. Their qualification must be in
Technical, do they have technical background also? No.
Postgraduate. Any postgraduate can apply for education.
My lords, education and law will not have technical background. Education law
will not be.
No, my lords.
But
They will
those who
have.
are otherwise, and maybe, but do you have in education? We just want to know out of curiosity.
Technical officers, no, my lords.
That are you running some kind of like within army, within your air force? Are you running some school, etc. also?
Yes, my lords. Yes, my lords. There are.
That's why I just want to know that this education must also be including your school teachers.
No, my lords, it does not include those school teachers. Those school teachers are unit run, my lords. Essentially, these are Air Force.
They are not part of this.
They are not part of this.
Just for clarity.
For the forces. These are training courses or other courses for the forces, Indian forces. In fact, my lords, your lordships are asking this question. One case comes to my mind, which a lady officer that I had represented, Colonel Mitali Madhumita, was an education officer of the Indian Army, my lords. She was the first woman to be awarded bravery medal, my lords, because in the teeth of a Fidaiin attack in Kabul, where she was posted for teaching the women of the Afghani army, my lords, in the Fidaiin attack, because they're all combatants. They are all weapon trained. They are all trained for all operations. So they are all trained for that. So she, my lords, she was in the teeth of that, in the eye of the storm, and she saved many lives, many precious lives. So she was the first woman officer to be given a gallantry award. Gallantry award is a non-peacetime award. So for her actions. So education officers are not, my lords, it's not like they will only teach. They are all combatants. They all have weapons. They are all, in the time of need, they will be. My lords, now a little overview of the Air Force before I take your lordships to the specifics case, my lord. Out of the 3 forces, Army, Navy, and Air Force, out of the 3, Air Force is actually called the most gender neutral, my lords, for the reason that Air Force, out of these, all of these 8 streams, 8 branches and their streams, women are there in all. Even fighters. So there is no branch or stream in the Indian Air Force which is not manned by a woman officer. It is available, open to all men and women officers. Then, my lords, secondly, your lordships have already been, my lords, informed that Babita Punia judgment.
The nature of duty in Air Force is such like that you don't stay like at border for hours, years and months and by nature of it, because the way they are supposed to perform.
Please, my lords. And technological enhancement, the fields to be open to, my lords, to the fairer gender in larger ways than it was possible
with the
for.
passage of time, they are not required even to cross the boundaries. They are not required to cross the border also. So maybe with the passage of
time. Lords, with the passage of time, now, my lords, people sitting on computer screens are actually are regulating the entire combat scenario. With the drones warfare, my lords, nobody is required to be there in a flying. In fact, it is said, my lords, that the last of the fighter pilots has already been born. There will be no further person who will be born who will be a fighter pilot, because that is, we can't afford to have people, my lords, in those fighter planes. So this is an area that has, my lords, on a personal note, I am here because I failed a pilot aptitude test of the Indian Air Force, my lords, some 30 years back. Otherwise, I would have myself been in the uniform, my lords. But it was my loss that I could not clear that exam. Therefore, I took to law.
All that you were destined to be in uniform.
Please, my lords. So, my lords, and in the Babita Punia line of judgment, my lords, Indian Air Force accepted the judgment of the Delhi High Court. The March 2010 judgment authored by Justice Kaul, my lords, as he then was accepted by the Indian Air Force. And therefore, the litigation that was here before your lordships, my lords, was only by Union of India in the Army case and in the Navy case. In the Air Force case, it was only the women officers, some women officers. So because what happened in Babita Punia Malaj in the Delhi High Court, the Delhi High Court noted that now the policy has changed. So we've always had the policy of short service commission on need-based Malaj. It was an ad hoc, there was no policy specifically. We used to take as per need, and the short service commission used to continue. Gentlemen officers were given the option of converting to PC. Women was started only in 1992. I have given that entire background, how short service commission really started in the Indian Air Force. 1992, first time women have started, and out of the three forces, Air Force was the first one. The first commissioning happens in the Indian Air Force for women officers, Malaj. Then in 2006, Malaj, by a policy decision, the permanent commission is discontinued for gentlemen officers also. Then, Malaj, the Babita Punia judgment, when it comes, the Delhi High Court notices that now the policy has been changed in Air Force, and now Air Force is not granting any consideration of permanent commission either to male officers or to women officers. And the High Court says that it is within the domain of the Union of India to frame a policy because these are defense forces, these are combat forces. We are not going to interfere in the policy decision of the Union of India unless some manifest arbitrariness is shown, which the High Court did not find. But the finding of the High Court was, till the time you were considering gentlemen officers, you can't say to women, if they are good enough for short service commission, they are good enough to be considered for permanent commission. So that was the background before the High Court, Malaj. And in that way, Malaj, but the High Court restricted the relief to all women officers of the Indian Air Force who were either serving or who had retired during the course of the writ petition and were part of the proceedings before the High Court. So, Malaj, that was complied with. We complied with. We did not come before your lordships. Air Force complied with it. The second round in Air Force really started with the Delhi High Court judgment, Malaj, where the women who were not covered in that category, because they had retired, they were not before the High Court and they had retired, they were not yet serving. They had retired before 2010. The judgment came in March 2010, so they had retired before March.
Before that, they had retired.
Please, Malaj. So they were not entitled to that benefit. That was the second round, which led to the Tayyaba judgment of your lordships, Malaj. High Court, they did not get any AFT. They went to High Court straight. High Court, they did not get any relief. And then, Malaj, your lordships passed some interim orders, directed reinstatement first of women officers who were meeting the certain benchmark as per the policy. So some women officers were reinstated. Those who did not fill the benchmark or who gave unwillingness. There were 2 women officers who said, we don't want interim arrangement because they were working somewhere else. So they said, we will wait for the final decision. So there were unwillingness officers also. Finally, in Tayyaba, your lordships directed that those who fulfill the benchmark must be considered for grant of pension. Then your lordships modified that order to say, because 20 years is the minimum pension, your lordships said that 20 years, you must take 20 years as pro rata. So commutation has to be on the basis as if they have served for 20 years, though they may have served for 11 years, 15 years, etc. So, Malaj, that is the sequence of PC journey of women officers. Now, in between, Malaj.
For Babita,
yes,
the officers, the women officers were, as you say, on SSC only.
Yes, Manoj. No option for permanent commission.
And allowing them to continue either 11 or maximum 14.
Yes. So, Malaj, initial terms were also different. The terms were initially different branch-wise. Flying was taken in for 14 years. But for other ground duties, Malaj, it was 5 years, 6 years, 4 years, or 6 years, 5 years, 4 years. I've given that also in a chart. But essentially, it was about 14, 15 years, which was there for others, in 3 tranches. Either it was 5, 6, 4, 5, 4, something, different tranches for different.
But Babita,
yes,
Babita, were they also entitled to any pension benefits?
No, my lords. Pension has always been for officers. 20 years is the pensionable service. For men, it is 15 years in all the 3 forces.
So there were no kind of a pro rata pension of that 11 years or 14 years or 15 years?
No, my
then proportionately you get.
No, my lords. In fact, earlier short service commission officers were not even given the status of ex-servicemen. That is only, my lords, later with progression.
Pension followed PC.
Bound to be, my lords. Bound to be, because you can't serve for 20 years as a short service commission officer. It ends at 14 years or maximum 15 years, my lords. One more difference, my lords, that was there was, so 2006 onwards, there was no PC for Air Force. From 6 to 10, There was no PC at all. 10, we restarted again only for a specific category of women officers which were directed by the High Court who were serving, or my lords who had retired during that period. Then, my lords, we faced a reverse gender discrimination case, my lords. The gentlemen officers went to AFT, and in 2011, the AFT followed the principles, my lords, of gender. They said that Article 15, you can't. So if you are considering women, then you consider men also. Then, my lords, Air Force had a rethink. And in 2011 onwards, we have been considering PC for all, my lords. So initially, the policies came in 2011, 12, 13. Then finally, in 2018 and 19. These are the two policies. Your lordships are only concerned with 19 policy because 18 policy is only qua flying branch. And there is no officer of flying branch.
But this, we will not use the word discrimination, but
Yes.
this gender-based distinction continue till what time?
My lords,
Gentlemen and
In Air Force, there was no discrimination.
no, it was
Because you said that there was no PC for the men also.
no, my lords, only from 2006. Till 2006, men were given the option of consideration for PC and women were never. Women are given for the first time in 2010. After the High Court, following High Court judgment of Babita.
So after 2010,
Yes, ma'am.
post High Court Babita, was there any gender-based distinction between gentlemen and women officers?
Yes, my lords, we gave it only to women. But then there was a judgment of 2011 on AFT where we were directed to give it to men. And therefore, from 2011, we started giving to all.
So, but that means you stopped for the men. They were already getting in 2006 onwards.
Before 6, they were getting. But then we felt that we don't need those numbers.
So you stopped in
We stopped PC for all.
for all in 6.
Oh, you stopped PC
We
for all.
stopped PC for all, my lords, which is noted in the High Court in Babita Punia and not interfered, not found, my lords, that it meets any of the requirements of being interfered.
So the gentlemen, they became beneficiary after Babita.
That's right, my lords. After Babita,
They got the benefit.
yes. So now the things have changed a little, my lords, in the sense that now the direct recruitment through NDA, my lords, is happening. And my lords, direct PC is slightly curtailed. And Short Service Commission is a bigger entry now because there a consideration has to be given to all, my lords. Those are the policies that your lordships have seen. Those are the policies now in Army and Navy also, Air Force also. The only difference is we give 3 options. But this 3 options is also coming only in the 2019 policy, 18-19. Before that, Air Force used to only give 1 chance. So prior to 2006, one chance for permanent commission consideration, and that 1 chance used to come at the end of your first tenure. So for example, if you have a 5-year, 5, 6, 4, then at the end of 5th year, you are considered for PC. If you have a 6.
But if you are not, say, shortlisted, then you will get another tonne as in SEC.
You can get 2 extensions. You could get 2 extensions, but then the consideration for PC was only at that stage after the end of first tenure. Then, my lords, this continued even in 2010 and 11. 10 and 11 policy also. Now the term was changed from 10, my lords, 10 plus 4 it became. So it became 14 years. So now PC was being considered at the end of 10th year. And after 2018-19, now PC is being considered at 3 options, my lords. And those 3 options are at the end of 9th year, 10th year?
11th, 12th and 13th.
Sorry, 11th, 12th and 13th. Now PC chances are given at the end of 11th year, at the end of 12th year, and at the end of 13th.
So one officer who doesn't make it the first round,
yes, my lord,
get 2 more chances.
Yes, my lord. Your lordship saw in Navy there was an
And this
second.
is uniform for all gentlemen and women both.
Now we have one policy that, in fact, we have 2 policies. One is for flying branch, that's men and women of flying up branch. Second policy of 2019, men and women of ground duties. So
But
these are not
the benefit of 2018 policy.
Yes.
Even to those, say, for example, women officers.
Yes.
Who, on hypothetical basis, got their first SEC, let us take in 2010.
Yes, my lord.
Then at that time, there was no permanent commission, but it came in 2010 probably.
Yes, my lord.
And say, for example, they missed one opportunity in 2011 or so.
Yes, Manoj.
But continued in SCC.
Yes, Manoj.
Have they also been given?
Manoj, everyone who is serving in 2019 will be given 3 chances, subject to them still being serving. If somebody retires after 2 chances, then he can't automatically ask for a 3rd chance. If somebody, in fact, there was one officer who did retire after the 2nd chance. She filed a petition before the AFT. She was reinstated, given a 3rd chance. I think she's also one of the officers here.
Yes, she's here.
Yes, she's here. So otherwise, my lords, the policy is that you will get 3 chances if you're serving. That is one odd case. We did not challenge that. We complied with it. But 3 chances if you are serving. But 3 chances have come only in 2018 for the flying duties and in 2019 for all other ground duties. So, Malad, one more important thing that is critical here is, Malad, what is being challenged is the essentially the scope of challenge in the Air Force matters is really very narrow. What the contest is, Malad, is that the MPCs, which is the minimum benchmarks.
Performance.
Minimum performance criteria, my lords, which is introduced in 2019 policy, that has been introduced for the first time, and that was not part of the regime earlier. My lords, each one of the officer has been asked to apply or give undertaking to be considered in terms of the 2019 policies. Or we have placed in this compilation, we have placed their willingness certificates, their options that they have exercised to be governed by this 2019 policy. If they were governed by the earlier policy, they could have only got 1 chance. There is no option of these 3 chances. And, my lords, on categorization, I've requested the officers and my lord put the aspect of categorization. This is something peculiar to Air Force. Your lordships heard this a lot, my lords, that categorization requirement. So the minimum categorization is C, then it goes to B, then it goes to A. Now categorization exams are also, my lords, they are held biannually, twice in a year. They are different for every stream. It's not a common exam for every branch. My lords, Air Force is a highly technical, technology-infused service, and therefore the duties and requirements and the whole purpose of categorization is to enhance knowledge. Because in technological enhancements, what was felt that categorization to enhance the knowledge of your own skill, of your own area of work is imperative. So categorization has always been mandatory in flying. It was always mandatory in one more branch, my lords, it's in the chart I'll show. For others, my lords, it was introduced progressively. In 2000, up to 2015, categorization is introduced in all. First, and when it is introduced, it's by an Air Force order. We call it AFO, my lords. These are like government orders. They're called AFOs, Air Force orders. So the Air Force order specifically says that this categorization is for enhancement of your knowledge, your skill. This will be linked to your career progression. Right now, it is not being linked, but the incentive is given. In some places, my lords, categorization earns a higher allowance also. As a category C, you get a higher allowance. As a category B, you get a higher allowance. Then the weightage in, my lords, in your appointments, in postings, in the assignments that you are given, in the courses that you are sent to, in promotions, and Short Service Commission to PC conversion for the first time in 2019 policy. But it was already in the system for all these years as an incentive that you must do it. We were, my lords, slowly coaxing, my lords, inspiring, guiding in many ways that you come to this categorization. And categorization is then, my lords, you can take this exam. So this is the exam that you take every year. It's held twice so that it can cover different officers. This is a large number of officers. So you have this exam you can take once. You have to hold that category for a year before you can upgrade, give an exam next year for either upgrading your category or revalidating your category.
This is annual exam?
Biannual, twice in a year, but you can give it, one officer can give it only once. Biannual, if somebody has missed the one date, then they can give it on the second date, but once only you can give in a year. But the validity is also for a period of 1 year, my lords. Next year, you have to revalidate or you can upgrade. In fact, I asked officers here to understand this. So, for example, the fighter, sir, can you stand up, sir? Sir, he's a pilot, my lords, in the Air Force. The wings denote that he's a pilot. Your lordships will see that the two, my lords, silver annotations on his pockets. This denotes the categorization. But he is presently in ground duties. Therefore, he has not validated his categorization. He is a category A officer, but he is a category A expired.
Is it for the purpose of enhancing and upgrading
Yes,
your technical know-how? And is it along with physical fitness or something more also?
Technical know-how. There are written exams, there is viva voce, there is a board that is set up. I will show to your lordships from the Air Force orders that this is the whole scheme of the categorization. Then, my lords, the other is courses. The courses, the minimum CGPA of 6.
Yes.
6 requirement of CGPA for the courses. That is the second aspect that has been added in this policy. Now, these courses are also have always been linked. In fact, to start with, it was categorically mentioned that these will be linked to career progression. They are counted again for assignments, for the postings, for the roles that are given for higher courses. There are some higher courses, my lords, for example, staff college, etc. All this will be considered. Also, they have my lords, the promotion, they have a similar system. Wing commander is the equivalent rank to a lieutenant colonel. So up to wing commander is time scale. From wing commander to group captain. Group captain is a rank which is equivalent to full colonel, my lords. And group captain's rank can either be by way of merit.
What is the base rank?
Wing commander. The flying officer is the first rank, my lords. I'll show that pyramid to your lordships.
Is it equivalent to lieutenant or captain?
Lieutenant. Yes.
So you start with wing commander?
No, my lords. We start with flying officer.
Flying officer.
Yes, my lords. If I can request your lordships to please take the first submissions, my lords, page 5.
So flying officer is the basic first.
Yes, that's the first post.
Officer.
Then after 2 years, and there is a course, you get flight lieutenant. So even for flight lieutenant, you have to have that course, my lords. Then there is another course.
Then some flight lieutenant.
Yes, my lords.
I see.
Then after flight lieutenant, it is squadron leader.
Squadron leader.
That is after 6 years of service as a flight lieutenant. Then from squadron leader with 13 years of service, you get wing commander. Up to here is time scale. Then from wing commander, my lords, it branches out. Either you can become a group captain after 16 years of service. After 16 years of service, you face the boards, my lords. That is merit based. Or time scale after 26 years of service. If you don't make it in the merit, then you can get a time scale colonel, like a time scale group captain you can get after 26 years of service.
So the group captain is based on is a merit reward.
Yes.
If you succeed in the competitive process,
please, my lords,
then you become group captain.
Please, my lords.
For that, is there any minimum service required?
Yes, my lords. Minimum service is 16 years.
16 years.
Yes.
So you can become, on 16 years, you can become group captain.
Yes, my lords.
Through a competitive process.
Please.
But if you don't make it, then you, if you complete 28 years of
26 years of service,
then you can acquire that.
Well, in that promotion also, there are 3 chances. It is a batch-based, the forces follow a very batch-based criteria, Malats. So your first option, you are considered with your batch. Then if you don't make it with your batch, you get then you're a first case of superannuation. Then you make it with the next batch. You can make it in the 3rd attempt. If you don't make it in all 3, you serve for 26 years. And after 26 years, you will get a time scale group captain, Malats. Malats, here again, Malats, the gap of shortfall of officers is in the first 14-year ranks. That is up to the rank of, below the rank of wing commander. The shortfall of officers, Malats, that is spoken about, and that is also one of the points that has been raised. The shortfall is not after wing commander, because after wing commander, it is the steep climb of the pyramid that starts. And from there on, Malats, these are all command-based positions. So, Malats, it has to follow that command-based positions itself.
Brigadier.
No, my lords, Lieutenant Colonel.
Lieutenant.
Lieutenant Colonel. Group Captain is equal to Colonel. Air Commodore, then my lords. Air Commodore will be Brigadier. Then is Air Vice Marshal, my lords. Then is Air Marshal and Chief of Air Staff. That is Air Chief Marshal. That's the Chief of Air Staff.
Oh, so you have Air Vice Marshal and Air Marshal and then Chief.
Please, my lords. Then, my lords, one more thing.
You are suggesting that in a pyramid structure,
yes, my lords.
You don't have scarcity at the top level.
Yes, my lords. Not after Wing Commander at all. In fact, we have the cadre is over.
But what about the base foundation? Do you have sufficient?
No, my lords. It is lacking in the first 14 years, 13, 14 years. We have shortfall in the first 13, 14 years. But my lords, Air Force also follows the same pattern. We have to have 2 recruitments every year. The whole idea of this, my lords, is that we have to have a young operational officers always. My lords, Indian Defense Forces are those rare defense forces where the officers lead from the front. It's not the men leading from the front, it is the officers leading from the front. So the operational age of officers is something that is very right, my lords. Everything we have to follow that. So I asked them also, my lords, how the personnel position is taken out in Air Force. Again, Air Force has a confidential personnel position. We are carrying in seal cover for your lordships to have a look, my lords. Like Navy, we are a smaller force, so it's confidential. Yardsticks are similar, like that it was there in Navy, my lords. It will foremost be the organizational functional requirement. Then, my lords, what is the sanctioned strength? Whatever is the deficiency. Then we don't even have a dynamic 15-year model that your lordship saw in Navy. Here we have a dynamic 5-year model, but that also is not, it is one of the parameters. In addition to the other parameters as to how the vacancies are to be filled up. Now, this vacancy is given by, my lords, the manpower division of the Air Force. And on the basis of that, the criteria that they consider are forecast of exit, then smooth cadre. There has to be a smooth induction in the cadre, smooth exit in the cadre. What are the new systems that are to be commissioned? What are new aircrafts that are to be commissioned? Not new flying systems, etc. What is the deficiency? And foremost, my lords, the organizational requirement, the Department of PP makes the cadre number. Also, how many are to be inducted? So we follow the induction, 2 inductions in a year, both for permanent commission and also for short service commission. Permanent commission essentially comes from NDA, my lords. NDA, it goes to Air Force Academy. NDA is 3 years. Last 2 years or a year and a half will go to the Air Force Academy at Dundigal, my lords. And the short service commission officers join there directly at Dundigal. They don't come through NDA. That is the scheme of entry in Air Force, my lords.
After 2010,
yes, my lords.
When you started giving PC, what is the highest rank that the women officers have been able to achieve?
Captain, even air commodores, they are coming up for the selection.
We'll just find out. All of them have made it to group captain. Air commodores also some, and I'll just find out what is the highest rank, my lords. Just find out.
Just so is the highest up to what rank?
Yes, my lords. My lords, Air Force also has an interesting, my lords, yardstick that the pilots have a faster promotion, my lords. The flying branch officers have the faster promotion. The chief is almost always a flying branch officer, always. So ground duty officers, their further promotions are not as fast as the flying branch officers.
But do they have a comparatively a short stint of their total career?
Yes, my lords. The stint will always be on the basis of the rank. So if you are only up to group captain, you will retire at 52.
No, among those who are the flying officers, those who perform in the air, I mean those pilots.
Yes, my lords.
Whatever the aircraft they are handling.
Yes, my lords.
Not the technical ground staff.
Yes, my lords.
Those who actually fly.
Yes, my lords.
Do they have any, because of the very peculiar nature of duty?
Yes, my lords.
Do you have any age barrier for them?
I don't think so, my lords. I saw recently the media reports of air chief landing into the highest airfield that has been opened in the higher regions of Ladakh, my lords. The maiden flight in a huge which assessment. Fitness assessment will happen, but there's no age restriction. Fitness assessment will happen. Every officer has to face that every year, my lords. Medical shape 1 is a requirement for all officers. For flying, there must be, my lords, there must be additional requirements. I'm not exactly aware, but there's no age restriction for the air chief flying, my lords. Correct? No, Rana, bench ke questions. My lords, may I now show to your lordships? Now, I think I've given your lordships a little bit of overview. My lords. May I take your lordships to the compilation, my lords, that I've handed over today, my lords?
Yes.
So your lordships may see the 8 branches, then the streams. Para 2, your lordships will find is the chronology of evolution of pre-rationalized SCC scheme in IAF. And your lordships will see that, for example, induction year 1985, it was aeronautical engineering, technical. Only men were there and tenure was 655. PC was offered at 5th year. Then in 1990, it started for helicopter stream of flying branch. Again, only men. The tenure was 564. My lords were asking me what were the initial tenures. So we've given in this chart, my lords, it's stream-wise different. And PC was offered at the end of 5th year. 1992 was the year when women started, my lords. And initially they started in all non-technical ground duty branches. That is admin, accounts, meteorological, logistics, and education. These are the 5 branches in which they started. PC was not offered. The tenure was 5 years, 6 years, and 4 years. Well, then in 1992, PC Short Service Commission is started for ATC and fighter control. Men 92, women 96. No PC, Malats. Then 93. Then para 3, your lordships will see. This is the rationalized SCC scheme in Air Force. This is presently also in vogue. Now the tenure became 10 plus 5 years initially, and then revised to 10 plus 4 years. Women were taken, my love, in all branches except fighter stream of the flying branch. Men were taken in all branches. Then your lordships will see para 3 has this chronology. 2003 is when the petition was filed in Delhi High Court by first a PIL and then writ petitions. 2006 is the cadre management exercise. So, my lords, the AV Singh committee was essentially meant for the army, but the aspects of cadre management and younger profile of officers is something that the government has accepted and mandated for all the 3 forces to be fine-tuned in their own way. So the younger age profile, the requirement of having continuous intake and not filling all vacant positions together. Your lordships can well appreciate, my lords, if we fill up all vacancies together, then all retire together. So we need to have that circulation always, and therefore the younger age profile requirement mandates us to have these exercises continuously. 2010, your lordships will see, this is the Delhi High Court judgment, my lords. So here, the benefit of the permanent commission was directed to be given to all serving officers and all petitioners who retired during the pendency of the petition. In 2011, my lords, the Government of India gave sanction to consider women, and 44 women officers were considered, out of which 42 were willing, and all were meeting QRs and have been granted PC, and all of them have become at least group captains. And your lordships have put that question to me. I'll find out that what is the highest rank that they've gone to. 2015 is the induction of women, my lords, as short service officers in the fighter stream. This was a watershed moment because this was the last of the streams that women were not taken. 2018, sanction is given to offer PC to both men and women in all branches commissioned after 2006. And Malad's 2022 is also important because NDA induction for women starts in 2022. That is also Malad's petition came to be filed before your lordships, and your lordships are directed by way of interim orders for us to start it, and then progressively from 22 onwards women are taken. Malads, I'll skip para 4, Malads.
Yes.
I'll skip para 4 because I've given that overview to your lordships, Malads, but this is essentially the evolution of the Short Service Commission. Then para 5 is, Malads, the policies. These are the human resource policies. They're called HRPs for grant of PC. The first policy was HRP 4 of 2000.
The overall policy of granting PC even to gentlemen officers in 2004 only.
Yes, Malad. Before that, need base on requirement.
Age difference of the two policies only 2004 and 2010.
That's right.
Because post Babita,
yes, Malad.
you brought a policy
yes, Malad.
for the PC of the women officers also.
Only.
So
first, we brought only for women officers.
So they missed hardly for 6 years.
No, my lords, women were never considered, though the policy has come for men only in 2000.
That's right. So
men were granted PC.
So opportunity to get PC, women officers have missed only for 6 years from 2004 to 10.
That may not be correct, my lords. Their induction started in 92.
Okay.
Their induction started in
1992 to 2004, as we get the understanding.
Yes, my lord.
Even male were not being.
No, my lords, they were being given. The policy comes, we frame a policy for the first time. Before that, it was by way of the requirements of the force on what were the vacancies that were available.
The practice of granting them PC was to the gentlemen officers.
Yes, my lords.
Was in vogue.
Yes.
Even prior to 2004.
Please, my lords. Please, my lords. That your lordships will get, my lords, in para 2 of this. Your lordships will kindly have para 2 again of this written submissions at page 1. Your lordships will see that PC was offered, my lords. From 1985 onwards, the induction started. Before this, my lords, there were some wartime commissionings. They were called emergency commissioned officers. But 85 onwards, the Short Service Commission started in a structured manner. And PC is considered for, my lords, all.
My lords, if I may just intervene here.
My lords, I don't have the charisma or, my lords, the flamboyance of my learned colleague, neither the constitutional understanding that my colleague has. So I will stick to my facts and I will request my colleagues, please, my lords, say what they have to say in the rejoinder. They will have an opportunity. And all that I want to show to your lordships is how the system has worked itself out.
In Air Force.
I'm sorry, I will not be able to match.
That's the thing. So women had served, and in 2004, the Air Force changed the
policy. That's why I kept quiet, my lords, when my colleagues were arguing. And
no, you didn't disturb them at all.
So, my lords,
they were also to the point. None of them wasted our time.
Please, my lords. And my lords, I will also
optimum utilization.
I will also submit fairly. If I don't know an answer, I have officers here to assist. I'll place it, my lords. But that's why I'm saying that it is not correct to say that women missed out only for 6 years, because men have always had PC. Though the policy is formulated in 2004, men have always been considered for PC. Women consideration comes for the first time in 2010. But these are the policies, my lords, in vogue. First is HRP 4 of 2004, where only men are given PC. Then HRP 21 of 2006. This was the policy that stopped all PC. No PC in Air Force at all. So this was the policy. Then HRP 4 of 2010, that is para 5.3, is the grant of PC to women officers only, as per the directions of the Delhi High Court, my lords. Then HRP 3 of 2011 is framed after the AFT directs us when reverse gender discrimination is alleged, that you must consider male officers also. And my lords, therefore, this policy comes in. And para 7, your lordships will see, HRP 1 of 2019 is the first human resource policy for grant of PC to all Short Service Commission officers of grant duty commission, even after 25th May 2006, from 2019 onwards, 243 men short service commission officers and 177 women short service commission officers have been granted PC. And this is for the first time, Malats, that the 3 options are also introduced.
Yeah.
Then your lordships will see para 8, Malats, this is the concept of categorization. And I'll show to your lordships the AFOs also. But categorization provides a framework for capability assessment, which allows an organization to evaluate and recognize professional competence of officers, thereby inculcating a sense of pride in them for high performance. Purpose of categorization. Categorization is a means of validating officers' competence with respect to capability, skill, knowledge, and acumen in professional traits. Continuing professional development is an essential aspect of ensuring that professionals maintain the currency of their knowledge and skill to undertake increasingly complex tasks. The competence mapping has twin benefits: an individual who can demonstrate his or her abilities and an organization that can reap benefits of the higher professional caliber. The overall aim is to develop a system of enhanced professional competence and knowledge base amongst officers, resulting in high serviceability, reliability, and ultimately operational preparedness of the fighting force. So aim of categorization is to enhance professional system to assimilate and disseminate knowledge of organizational benefit, develop motivational system to assimilate and disseminate knowledge of organizational benefits, standards, so and so. Then para 9 is important, my lords. Categorization, how it is carried out. Categorization for various branches is conducted by earmarked agencies for the same, such as Directorate of Air Staff Inspection, Ground Duties Officers Categorization Board, Maintenance Officers Categorization Board, etc. Categorization includes written examination followed by practical test on a system and viva conducted twice every year at categorization centers nominated for the purpose. To cater to large pool of officers, categorization board is held biannually, offering 2 opportunities in a year as per published program for officers to upgrade or revalidate their categories as per periodicity. The overarching aim of categorization is to improve overall skill set and empower human resource of the organization towards enhancing operational efficiency. It lays down framework for objective assessment of an individual in terms of his professional competence and caliber for recognition, reward towards professional growth. And then Mala's recent report has happened. We are carrying a copy if your lordships like to see that categorization has actually enhanced the operational skills of the Air Force. And your lordships will see this table below this, Malas. These are the categorization is used in all of these. So select promotion ranks since 2020, grant of PC to SSCOs, criteria and key field appointments, diplomatic assignments, postings abroad, cross-streaming of AE branch officers, and then how it has been introduced. Flying branch, it has been since beginning. Because flying Malad's machine upgradation and the technology upgradation, software upgradation has to be a continuous process. that it can be integrated with AR grading that for the purpose of discerning merit. Since mandatory in-service course and CGPA was in vogue since 2008, and applicants were also aware about the same since their commissioning itself, the same will be utilized in future in their career progression. And therefore, my lords, then kindly see page 9. This is a comparative chart that we have made, my lords, of the HRPs. The 3 HRPs on the left side is HRP 2004, 2010 and 11, which is prior to the 2018-19, and the right side is 18-19. So your lordships will see that on the left side of the column, my lords, it is all single consideration. The requirement of the first policy is applicable only to gentlemen officers. That is a 4 of 2004. 2010 policy was a single consideration for women officers in pursuance of the Delhi High Court judgment. And 2011 policy is for the gentlemen officers. Then
single consideration means only for gentlemen.
Only once. Only one.
Only once. Only one opportunity.
Only one opportunity.
Multiple comes only in 18.
18 for flying branch and 19 for ground duty branches.
But say for 18, when you introduce this, giving 3 branches.
Yes, Manoj.
All 3 are based upon the service record of maybe 2010, 2011 onwards.
Last 5 years. Last 5 years, my lords.
Last 5 years.
Preceding 5 years. So I will show that to your lordships that for
Was there your criteria of maintaining the service record was also same?
my lords, that has been same. In fact, we have the same system of ACRs, which is akin to Navy. I am carrying in the compilation. There is one empty ACR for your lordships to see. Starts with the self-assessment, and then, my lords, it follows a system of closed assessment by the IO, by the RO, initiating officer, reviewing officer.
Your ACR format doesn't have any gender-based distinction.
Not at all, ma'am. In fact, all our policies now from 2018 and 19. Earlier policies, we were responding to the orders, my lords. Therefore, your lordships saw that the earlier policies, the first one was only for men, second is only for women, third again only for men. 2018 and 19 onwards, these are now branch-wise. 18 is for all flying, 19 is for all ground duty, and applicable across the board for all men and women across the board. In fact, your lordships will, after this, after 2 o'clock, my lords, I'll show to your lordships what is the merit position of each of the applicants. It is not like they are just the next. There are other officers in between. So your lordships will have to see that one, AFT notices, my lords, that one, they have all given willingness. They have all given willingness to be considered by this policy. They avail of 3 opportunities in terms of these policies. And after giving willingness, after availing 3 opportunities at the fag end, then they challenge this, my lords. I'll restart, my lords. I'll continue at 2.
How much time you need?
My lords, maybe about half an hour if your lordships may permit.
No, we are not curtailing the time. We just want to know.
There are
and
some
after
judgments.
half an hour, if you give 10-15 minutes this side.
Yes, we'll need
Actually,
to
my lords, I may need 45 minutes because I have to show some judgments also, that chronology.
5 plus 15, 1 hour. And can we finish the Coast Guard also together?
My lords, I'm not appearing in Coast Guard matters, my lord. The learned AG is appearing in those matters. And my lords, the paramilitary, my lords, Coast Guard is in any case paramilitary. Coast Guard is in any case paramilitary. Your lords complete the 3 defense forces.
There is no commonality of.
No, my lords, it will be a completely different spectrum, in fact.
That means for 3.
Yes, my lords.
The Army, the Navy, and Air Force.
Yes.
These battles we can take.
Yes, cohesively, collectively, same principles.
Right, so please help us in finishing the matter in any case.
This aspect which my learned friend is pointing out with regard to no discrimination, that we will have to rejoin.
Yes, that will take a little time to rejoin, my lords.
Lords, with your lordship's permission, that item 119 is that constitution bench that Rajneesh on the district judges, it's basically the implementation of that constitution bench, which judgment.
Appointment of
Yes.
Is it a regular matter?
It's a regular matter.
It has gone to the regular.
It's gone to the regular list. It was in fact.
What was the issue?
It was about those district judges, my lords, where the civil judges who had taken part. Sorry. No, I know that. Just the question was only whether they were eligible to take part as the direct recruits. Your lordships have said so. You've overruled the earlier judgment of 3 judges and said yes, Dheeraj More has been over.
That's 7 years issue.
Correct.
Yes,
That's correct.
yes.
7-year issue.
So the
Follow up, just implementation of that for
Very specific cases.
Can we take a chance around 3:15?
very well.
Very well.
By that time because we are continuing.
Yes.
Going by the timeline.
Yes.
To take an hour or so.
Yes.
And then maybe so on safer side 3:15.
Very well. There's a amicus.
There is an amicus. We'll inform the amicus. There is an amicus.
Grateful, my lords. Grateful, my lords. Grateful.